Good evening and welcome to Law and Other Things podcast. For those joining us for the first time, Law and Other Things is one of India's oldest public law blogs, founded nearly 20 years ago by scholars and practitioners committed to making constitutional conversations accessible, rigorous, and publicly engaged. Over the years, the blog has served as a forum where academics, lawyers, judges, and students have reflected on developments in constitutional law, administrative law, federalism, rights adjudication, and institutional design. Our aim has always been to bridge the gap between the courtroom and the classroom, and between doctrine and democratic debate. This podcast initiative grew out of the same vision. We wanted to create a space where complex constitutional questions could be unpacked through candid, in-depth conversations with leading practitioners and scholars. It is therefore a privilege to host Senior Advocate Mr. Arvind Datar for today's discussion. Mr. Datar is one of India's most distinguished constitutional lawyers with decades of experience before the Supreme Court and various high courts. Mr. Datar, thank you so much for joining us. We are truly delighted to have you with us. The main topic around which today's podcast is based is your recent landmark victory in Madras Bar Association versus Union of India. Without further ado, let's get into our first point of discussion. The Tribunals Act actually said its provisions would apply notwithstanding anything in any judgment, order, or decree of any court. That's a pretty bold statement. How did the Supreme Court react to the legislature essentially declaring its law above prior rulings? Have you seen this kind of language before? And what does it signal about the tussle between the government and the judiciary here?
This non-obstante clause has been used in the recent past, used earlier also, but recently, if they want to get over a judgment, they simply say notwithstanding any judgment, decree, order of any court, tribunal, authority, and they pass whatever law they want. But as you see, Justice Nageshwar Rao's judgment, he has referred to a number of cases that this is impermissible. If a judgment says that A plus B is equal to C, then the law can't say notwithstanding any judgment, A plus B will not be equal to C. So you can't have a legislative overruling of a judgment, but you can remove the basis of the judgment. You can remove the basis of the judgment by altering what the position says. Suppose, for example, Supreme Court says that shares are movable property. Then you can't simply say shares are not movable property. You can't do that. But you can say the definition of a share will not fall within the definition of goods under the Sale of Goods Act. So you can amend the definition so that the basis of the judgment is removed. In other words, the amendment should be such that if the amendment was the law, the court could not have passed the judgment. Just putting a non-obstante clause is not a permissible way of getting over a judgment. Otherwise, any judgment can just be got over by simply saying notwithstanding anything contained, whether it's a Sales Tax Act or a Labour Act. You cannot simply say notwithstanding. You have to follow a particular process.
Thank you so much for that detailed response, sir. We truly appreciate you taking the time to unpack these complexities for our listeners. Building on what you just said, the government argued that the court's earlier prescriptions on things like tenure and age were just suggestions, and that ultimately these are policy matters for Parliament to decide. How did the Supreme Court counter that argument? Where did the judges draw the line between valid legislative policy choices and breaches of constitutional principles like judicial independence?
See, these are not suggestions. Right from Sampath Kumar, they have made clear, see, these tribunals have taken away the jurisdiction of the high courts or the Supreme Court. And now they are doing what the courts were doing. Observation of Justice Bhagwati was that in the administrative tribunals, if you put a person for just 5 years, by the time he gets to know the matter, it will take 1 or 2 years for him to understand the subject if it's a brand new branch of the law. And he said that 5 years is too short a period, let it be an automatic extension of at least 5 years. So this is the verdict of. Similarly, this 5-year period was emphasized by the first R. Gandhi, first NBA case in 2010, saying that it should be an automatic extension unless the member is found there's some allegations of corruption or other impropriety. He should be continued. Extension should be automatic. Now this became 5 years. That 5 years was made to 3 years. 3 years was struck down in Roger Matthew by Justice Gogoi's bench, headed by Justice. Now they said make it 5 years mandatory. As a kind of, I don't know, it's a prestige issue or just to prove a point, they said, no, we'll make it 4. We'll not make it 5. Because the Supreme Court says 5, I will not make it 5. I'll make it 4. So I don't know who's benefiting by this. Suppose I have joined the company law tribunal and you appoint me for 4 years or 5 years. By the time 4 years are over, I've understood the law, I've developed a lot of domain expertise. Suppose tomorrow, as a young member, you become member of the company law tribunal, or say, for example, the securities appellate tribunal. You learn the securities law. After 3-4 years, you get a very good grip of the subject. Now, the taxpayers' money has been used to pay your salary, and you have developed human capital. After all, this is all human capital. And you have developed knowledge. By appointing you 4 more years, there is no doubt that your disposal will be much higher because you understood the subject. By that time, 4 years, you've fairly got a full grip of the subject, and next 4 years, you can dispose much more cases, lay down better law. Now, a person comes for 4 years and then he is gone and he can't go back to the same branch of law. If you're in company law tribunal, you can't come back and practice through company law tribunal. There's no company law in the courts. So, if you're a company law expert, who will come for? That's why you find all the people in the company law tribunal, nobody knows company law initially. All have come from IRS or have come from district judiciary or are advocates who have never practiced company law and will never again practice company law. What kind of a system are we developing? So this is not a policy matter, and ultimately, I think the aim of is to get the best possible tribunal, get best possible talent to dispose cases. If you have people without tomorrow, if you appoint me as say in a PMLA tribunal, I have no knowledge of criminal law. I'll do a mess. But after 4 years, I'll get some knowledge. Why ask me to go after 4 years? Let me continue for another 5 years. Why make it as a prestige point? But they're adamant that it can't be more than 4 years. I don't understand.
Yes, sir. That actually clarifies the issue beautifully for us, sir. I think you've really unpacked the constitutional tension at the heart of its debate there. Taking that forward, one big outcome of this case is that the Supreme Court didn't just strike down provisions, it also directed the government to set up a National Tribunals Commission within 4 months. What is this commission expected to do? And why is it seen as a solution to persistent tribunal woes? In your view, will creating this independent oversight body finally address the problems that would have led to repeated court interventions?
See, in the UK, when you had the Major Tribunals Reforms Act reform made after the recommendation of the Lord Legate Committee, one of the most important things suggested was a tribunal should be perceived to be independent. See, the point is justice should be not only done but should be seen to be done. That the public must feel that, look, if I go to this tribunal, I'm not going to one more government department. I am going to a place where there are independent members like judges. That's why it's called quasi-judicial. It's not a judicial, it's quasi-judicial. But when I was a junior, the Income Tax Appellate Tribunal dealt with income tax cases. It was under the law ministry. It was completely independent. It was a fantastic tribunal. So the suggestion of the suggestion was that, like in England, all the tribunals come under the Lord Chancellor, under the law ministry. Here also we said that, look, you can't have the excise tribunal under Finance Act, you can't have the labor tribunal under the labor ministry. Then you are just like a department. You're depending on your ministry for your staff, for funds, etc. Invariably, people will perceive it to be a wing of the government. What justice can I get? Where I'm agreed by a government order and I'm going to the government to challenge it. What kind of justice will I get? So in Chandrakumar, they said, have an independent nodal ministry for this thing. That has never come despite the judgment being 28 years old. We recommended in Roger Matthew that have a tribunals commission, because once you have a tribunals commission that can take care of the infrastructure needs, it can be under the law ministry. That tribunals commission can be headed by judges, retired civil servants in a particular combination. They can take care of selection, staffing, promotion, housing. Just as the Ministry of Justice takes care of the judiciary, you can completely take care of all the needs. And once it's a National Tribunals Commission, they don't have to bother about their parent ministry. It's a welcome measure, but I don't know if they are going to implement it, because many judgments of Supreme Court, they don't implement at all. It's a very unfortunate part. But at least, see, the point is, we have to ask, is it in the interest of the nation? Is it promoting ease of doing business? Will it promote Viksit Bharat? You can't have a large country where the tribunal system is not perceived to be independent. You want to be a first world country, third largest economy and so on. Then have tribunals like what they are in UK, Germany and so on, which are completely independent. You can't want to be a first world country and have a third world, fourth world kind of bureaucratic setup.
Thank you so much for that response, sir. Your experience in these matters really shows in the way you've broken that down for us. Thank you for walking us through it so clearly. That leads us naturally to the next concern. In the case, the court struck down provisions of the Tribunals Reform Act on the ground that they were verbatim or near verbatim reenactment of clauses already held unconstitutional in earlier rulings. Does this judgment expand the scope of judicial review to include legislative process, specifically attempts to override binding judicial directions?
This actually is tied up with your first question on notwithstanding.
Yeah.
Here they did not even do notwithstanding. Here only one part they did notwithstanding. The tribunal's ordinance was struck down somewhere in 11 July or some, and within 3 weeks they passed the same act, which in my experience of 4.5 decades is unheard of. I have not seen anywhere in history where Supreme Court has struck down certain provisions and you simply reenact the same provisions again, perhaps unprecedented. Argue at this point that look, there is a particular section, I strike it down. You can't enact the same section. You'll have to remove the basis, make a new law, try to get over the judgment. Ultimately, Parliament can make the law. It can change the basis of the law. For example, they say sale will not include works contract because sale only means where there is transfer of property. Then you have the 46th Amendment. It says sale will also include amend the Constitution, amend the Act, amend the rules. But you can't simply say pass the same rule and the same law all over again. Not only legislatively impermissible, but it is not showing due respect to the courts which have laid down the law.
Thank you so much, sir. Another important case that you're involved in at this point in time is the Gameskraft versus Union of India. I have had the opportunity to listen to you argue that case because I was interning during that time, and I had gone and written on the taxation aspect of it with an advocate on record on the taxman also. So you have really inspired me in that one case and how structured and sharp and innovative your arguments were. So my next question would be on that case. The whole sunrise sector of online gaming industry is on the brink of disappearing due to the change of the tax rates and the whole erasing of the distinction between the game of skill and game of chance, which is being held since the RMD Chimarbagwala case. So what is your take on the present status of the industry and how the case is going to take its course in the coming times, coming hearings? And yeah, your take on that would be great, sir.
Well, as far as the law is concerned, from 1957, Chamarwawala's case, where they discussed the Price Competitions Act 1955, it has been consistently held that playing games of skill is like having a business. You're protected by Article 19(1)(g). That distinction cannot be erased by mere legislative. What they can do properly, they can levy the same amount of tax. They say whether you're playing game of skill or game of chance, I levy a tax. So that's permissible. But you can't prohibit a game of skill today under law, is my opinion, because you have to amend the constitution for that. Perfectly legitimate. You can't take away my 19(1)(g) right. Fortunately, the new act which has come, which has not yet been notified, has completely crippled, or if I may say, destroyed the whole industry. There are newspaper reports that a lot of gaming has gone underground. The government lost 18,000 crores of revenue by this particular ban. By levying 40% of tax, it's one thing to say you can play the game and one thing to say I'll levy 50% tax. Nobody's going to play at all. Because if you levy 50% tax, every 10 rupees I play as a winning, as a bet or as an entry fee, if 50 rupees is going to go as tax, 10 rupees is going to go as platform fee, then all of us are going to share the remaining 3 rupees and 4 rupees. So it's one way of ultimately destroying the whole sport. I have never understood this rationale of banning this. The argument that people are committing suicide, people are doing this, and then so is alcohol. You're permitting that. So that's not an argument. You see, in any game, if there are 1 million people playing, if 10% commit suicide, that doesn't mean ban the whole game. There are people extremes who will get addicted. Like recently, some young girls jumped off on the Korean game. Very unfortunate. So this is part. And I don't know who's winning. Ultimately, websites in Dubai and so on are making money at our expense and we are losing all the tax revenue. And I thought that after the meetings with the finance ministry and altering the taxation proposal, it was all going smoothly. 28% was the tax, people are reconciled to that. Sudden ban is, apart from this, more than $3-4 billion had come as investment by private equities abroad. They came in money thinking that they will invest in India. So many people, every gaming has got, like some large companies, are 800, 900 engineers are working. So they keep on updating the software, regulating the It's a huge set of techniques. Everybody has lost their job. And for what? So people have worked for 3-4 years, developed skills as gaming experts. Now they've all lost their job. And 3 billion investment has come. Overnight, you could at least say that, look, we'll be phasing it out over 4 years or 5 years, or give some reasons, or at least make some provisions. And the rules now are even more draconian. Gaming is over as far as India is concerned.
So that would remind me of the recent 2025 Act that came in, the Promotion and the Regulation of the Online Gaming Act, and also particularly the federalism issue that is embedded in that
Yes, yes, yes.
act, about how the state betting and gambling falls under the state list, but the union, to justify their legislative competence, had given reasons like entry 52 of the list 1, which said that in public interest we can take care of some industries. So what would be your take on the federalism angle of that act, and how does that act relate to the ongoing Gameskraft case that's in the Supreme Court?
See, I don't think Parliament can get into it, because unless they amend the IDR Act, Industry Development Regulation Act, or identify the Essential Commodities Act, normally all trade commerce is the state subject. But apart from that, the larger issue is whether it's Parliament or whether it's a state legislature. You can't ban games of skill. In a democracy, Republican democracy, where it's 19-1 rights are there, you can't ban it. So one is a federalism issue, number one, and because betting and gambling is a state subject. So it's, for example, Sikkim may want to permit gambling, Goa may want to permit a casino. How do you do it online? If you can have physical casinos, why not have an online casino? Well, what's the logic? So they say no, online is coming under entry 31 telecommunication. That court will have to test it. But there is a federalism issue, and larger issue is how do you get over a 5-judge bench judgment which has stood the test of time for last 57 to 25, almost 60 years, 70 years.
Yes, sir. There was this one argument. I was recently making my research paper on it, and I had come across this one argument which had said everything that becomes into online format. Now, if we go by the same argument that the union is making, everything that becomes online format, the union would have legislative competence on it. But the pith and substance test does not really allow that, because just because it becomes an online format, because of the digital economy, which is happening a lot more, then anything being sold on websites, then even if it is in the state list, then the union should get competence.
Absolutely. Even for agriculture, just because I promote seeds on online, or I give inputs to farmers online, that doesn't mean you get the control. You're absolutely right.
Understood, sir. Taking that forward, sir, another important doctrine that is muddled in the whole gaming cases is the res extra commercium. Could you trace the theoretical origins of the res extra commercium doctrine and explain how it evolved as a constitutional tool for excluding certain activities from the protection of trade and commerce? In your view, is its application in India, particularly in areas like gambling, liquor, and online gaming, conceptually coherent, or is it doctrinally ill-suited to structure and rights framework of the Indian Constitution?
RMTC understood res extra commercium, that they say res extra commercium is commercial activity, and they thought extra commercial activity like extra judicial, take the law we call extra legal methods. So what we say is something beyond. So they thought res extra commercium means something which can't be taken as commercial activity like drinking, gambling, so on. That is not the meaning of res extra commercium. Res extra commercium is a different meaning in Roman law, as I wrote in my article. But anyway, I didn't want to waste time. I said at least in India for 70 years we are using res extra commercium in our own law. So for India, res extra commercium means commercial activities which are socially harmful. We'll keep it at that. So that's technically they are wrong, but now it has taken an own meaning. Like some particular word may have a different meaning in America, may have a different meaning in England. So now that's the meaning of the word. Like for example, if you take the word gay means something very joyful and so on in the actual dictionary. But now gay means a sexual orientation. That's now the new meaning of the word. So it's okay, fine, I'm not on that. And again, I can say that games of skill can never be res extra commercial. At the most, games of chance can be. And you see, beyond a point, you leave a person alone. I mean, to stop this moral policing, you can't play online game, it's affecting the morals, this, that, and so on. Just leave people alone. Somebody wants to play cards in the evening, he's way enjoying life. If I want to play poker, I'll play poker. Just leave. The right to be left alone is such an important right.
Understood. The government went to the extent of saying that, like, completely removing the difference, and said merely just the minute you stake money, the difference between games of skill and games of chance is gone. And because you stake money,
That was the argument in the case also. No? It's the moment you
Yeah,
put
yeah,
a
yeah.
stake, it's a,
The moment you put a stake, it is done. Okay, sir. Thank you so much, sir. That was a
thank you.
very, very insightful interview for us, and we
Wish you
hope
all
to
the
do it
best.
in the future.
Wish you all your colleague classmates all the best. Thank you. God bless.
Thank you, sir. Thank you. Thank you to our listeners for listening to the LAOT podcast. We will come with more content soon.